guardianship and conservatorship. We are going to emphasize guardianship, and we'll tell you why we're not going to particularly spend a lot of time on conservatorship. We are mostly going to talk about guardianship of adults. Much of what we say will also apply to guardianship of children, but not all of it by any means. Mostly, we'll spend the first third or so of the time telling you why you shouldn't do a guardianship and what your alternatives are. Because in a general way, it would be nice to avoid doing a guardianship if you could do it. So we'll kind of work through some of the definitions of terms and what some of the alternatives are to make your life, we hope, a little bit easier. When Elizabeth and I first started practicing law, and certainly when I did 30, almost 40 years ago, representing yourself in a guardianship was pretty much unheard of. No one would ever do that. You hired a lawyer to do that, and we expected that there would be lawyers involved in every case. Today, we think that the number is on the order of 40 or 50% of all guardianships, and if you do guardianships of minors, more like 90% of guardianships are filed by people without lawyers. There are lawyers in adult guardianships, as we'll explain to you, appointed by the court to represent the proposed ward, and so there's at least some lawyer hands-on effort in most adult but no minor guardianships. And so there's a little bit of legal help there, but most people are not hiring lawyers to do guardianships. Now, we lawyers could rail about that. We could say, don't you appreciate that you need us? You wouldn't do your own brain surgery. You wouldn't even do your own carpet installation. How could you possibly do a guardianship? And we do rail about that, and we do think we add value. But we also recognize the reality that you're not hiring us. And so our point in doing this is trying to give you enough information so that you don't flounder around without having any success and getting more and more frustrated if you go forward and do it yourself. And also to let you know what kinds of things you really do need help with and what kinds of things you're more likely to succeed with on your own. And we're pretty upfront about that, pretty candid. We appreciate that we're not going to be involved in every guardianship case, and the greater good is served if you kind of know what you're doing as you go along. That's our purpose today. So let's start with a little bit of a definition of terms. Here's a question that I get asked a lot. Should I get a guardianship or should I get a power of attorney instead? It's a very commonly asked question, and it's a very bad question because it's not that kind of choice. You have to understand what a power of attorney is in order to even understand what's wrong with that question. A power of attorney is something that I, a competent individual, might give to Elizabeth or Ryan. Actually might give it to Elizabeth, and if she can't do it, then to Ryan as the backup to make decisions for me. But when I sign a power of attorney, I have signified that I understand what I'm doing. I was competent when I did it. If I don't sign a power of attorney when I'm competent and I become incompetent, then Beth or Ryan are going to have to initiate a guardianship. So the way I try to explain it to people is a power of attorney is a volitional act done by a competent person to delegate authority. A guardianship is a thing done to an incompetent person to give someone else the authority to act. And so when you come in to see me and say, which one should I do? It's a false choice. My question is your mother or your father, whoever we're talking about, are they incapacitated? If they are, we can only talk about guardianship and what you might do to get around it. If they are not incapacitated, then yes, they might be able to sign a power of attorney. Now, if you're sitting there thinking, what about myself? Or, yes, I believe my dad is competent, and should I rush out and get him to sign a power of attorney right now? The glib answer to what's the difference between a power of attorney and a guardianship is about $3,000. Because if you come to a lawyer's office, and say, I want to sign a power of attorney, I don't want to do anything else. I don't want to sign a will, don't want to sign a trust. I just want to sign a power of attorney to give power to my children to make decisions for me. How much is that going to cost? First of all, the lawyer is going to say, come on, let's talk about wills. You need to do some other things too. But assuming that they're willing to just sign that power of attorney, the cost, I predict, is going to be in the range of about $200 to $300. And if you could go online and find a power of attorney, and in a minute I'll tell you how to get a perfectly good healthcare power of attorney for free, then the answer is it's free. Whereas if you come into either Elizabeth's or my office to talk about guardianship of your now incapacitated dad, we're going to tell you that by the time you have paid us, paid the courts, paid the court-appointed attorney, paid the doctor to write a report, paid the court investigator to go out, probably you're going to be in the range of $3,000 to $5,000 if everything works pretty smoothly. So it's a pretty expensive proposition to do a guardianship, and it's way more efficient to give powers of attorney. Now, there's a flip side to that for you thinking about, do I need to go home and sign a power of attorney? If you sign a power of attorney, there's no oversight. There's no agency that's deciding whether your son or daughter is making the right decision. There's essentially nobody looking over their shoulders. And at least with a guardianship, there's the whole machinery of the courthouse looking over the guardian's shoulders. And so, you know, it's not an apples to apples comparison when you think about the two systems. As you do this, you might think, you know, I just soon leave it to the courts, even if it is more expensive. I doubt that you'll say that, but you might say that for yourself, and your folks might have said that when they were thinking about it. And that might be why they didn't sign a power of attorney. I've just sort of glibly talked about powers of attorney as if they were all one kind of thing, and failed to distinguish between two different kinds of powers of attorney. Generally speaking, powers of attorney are usually divided into two kinds. There are those that deal with healthcare decisions, and there are those that deal with everything else. And everything else usually means financial things. So a power of attorney to allow Elizabeth and Ryan to go handle my bank account usually gets called a financial power of attorney, whereas a power of attorney that allows them to admit me to the nursing home usually gets called a healthcare power of attorney. In Ryan's world, there's also something called a mental health care power of attorney. I can give Ryan a power of attorney that allows him to admit me to a locked down psychiatric treatment ward, and I can make it irrevocable so that when I'm in the ward and he's signed me in and I'm screaming, "Let me out, I revoke the power of attorney," Ryan can cackle meanly and say, you can't revoke it because you are now incapacitated by your mental illness. And so if you have a relative with an extreme history of psychiatric problems, you really want to be talking about a mental health care power of attorney, in addition to just sort of garden variety health care. One of the words you often hear is durable power of attorney. Usually when people say durable power of attorney, they are probably talking about a financial power of attorney, because by definition, healthcare powers of attorney all have to be durable. Durable just means the power of attorney is still vital, still valid, if you become incapacitated. The reason for that distinction is, until the 1950s, nobody ever heard of such a thing. It's a relatively recent invention. In the law, something that's only been around for, I don't know, longer than me, is usually referred to as a relatively recent invention. If it's been around for 500 or 600 years, then it's traditional. And most of this area of law is traditional, but this durable power of attorney idea is pretty new. And in fact, it has taken the world by storm so much that today every power of attorney is durable in Arizona unless you explicitly say that it is not durable. So a durable power of attorney is no longer a very meaningful designation, but they usually mean financial power of attorney when they say that. Another term you often hear is springing power of attorney. The power of attorney springs into existence only if I become incapacitated. So I might have given, in my power of attorney to Elizabeth, I might have said, she has no power to act unless 2 doctors certify that they've examined me and I am completely incapable of understanding or articulating anything in the English language. I could make that the terms. I hope nobody would sign that power of attorney, because that makes it extremely hard for this power of attorney to spring into existence. But you could. Usually, either the power of attorney will say, until a doctor says I'm unable to make decisions, or it won't describe it, and it probably means until a doctor says I can't make decisions. That's a springing power of attorney. A healthcare power of attorney usually is springing. A financial power of attorney might or might not be springing. So just calling something a springing power of attorney doesn't even tell us whether it's healthcare or financial. And we can do powers of attorney for driving. We can do, oddly, a power of attorney to allow your agent to make funeral arrangements. We can do a power of attorney to allow your agent to make autopsy decisions or organ donation decisions. So there's a whole bunch of different powers of attorney out there, but the big broad brushstrokes are healthcare and financial. Want a free healthcare power of attorney? Jennifer has helpfully brought me a copy of the packet that you can get from PCOA or download from the Arizona Attorney General's website. Life care planning is the phrase on their website that you can click on. There's nothing wrong with this power of attorney. I direct people to do it a lot. And so it's a fine way to do it. But remember, you can't sign this and your mom can't sign this unless you or she is competent to understand what's going on. It will be notarized, it will be witnessed by people who are not you, so they're going to have to convince a couple of non-family members that they know what they're doing. What would be a measure of competence? It's a pretty low level of competence required. So when I talk to a potential client about doing a power of attorney, my questions are, do you know why you're here to see me? If they can't tell me, they say, ask my son, he's sitting out in the front, then that's a negative check mark. Doesn't mean we can't proceed, but it immediately makes me think they're not really tracking on what's going on. Oh, your son brought you down to do a power of attorney. Do you think that would be a good idea? I don't know. Do you think it would be a good idea? That's a check mark. But if they say, oh yeah, power of attorney, that's right, he did tell me. I don't have any documents. I better do a power of attorney. Oh good, that indicates that they understand what the concept of power of attorney is. So as I say, it's a pretty low threshold, at least in my office, but you got to have some level of understanding before you can sign that power of attorney document. Memory is important. People who have Alzheimer's type dementia typically have their memory attacked early in the process, but I think judgment and what sometimes the doctors call executive function is more important than memory. And executive function is, if there were a fire in your living room, what would you do? Really? How did a fire happen in my living room? That's a black mark. That's an indication of a lack of executive function. Suppose the person named as the agent begins to slip. And that's why I said when I'm going to name Elizabeth as my agent, I'm going to name Ryan as my backup. And I'm going to say in my power of attorney, Elizabeth is no longer my agent if Ryan signs an affidavit saying she's lost it even faster than I have, so that there's some kind of a mechanism. When I do powers of attorney, I want at least one backup person of the next generation. So when your husband names you, I want one of the kids or a neighbor or your minister or somebody who's a few years younger as the backup, just as sort of a safeguard. So that's powers of attorney. A lot of misunderstanding about them, and a lot of mythology about them, but it's not really all that hard to figure out. Now, when you talk to people in the social service and medical world, they will often say, you need a power of attorney for your mom. Oh, really? I do. Do you think that she's incapacitated? Oh, she completely is gone. She has no idea who I am or what she's doing here. Well, it's a little late to be getting a power of attorney, so don't tell me I need a power of attorney. We got to talk about whether we got to do guardianship instead. Sometimes you'll hear people say, you need to get a power of attorney for your mom. Oh, I have one. Here it is. She signed it 8 years ago when she lived in Iowa. Oh, you need an Arizona power of attorney. No, your Iowa power of attorney is just fine. Now that your mom's here, if she's competent, it might be good to get her to update the power of attorney. But if not, if she can't or if she won't, that 8-year-old document from Iowa will do just fine for almost every purpose. And at worst, you might have to hire a lawyer to argue with the bank or argue with the doctor. That's for every state. I didn't particularly mean to pick on Iowa. It's just my experience. That's where everybody came from. So, not only every state, but every territory and every other country, although powers of attorney are not common in other countries. This concept is a kind of an American concept. And now we get to guardianship and conservatorship. Okay, little language. Arizona uses the word guardian to mean a person who has been given authority over the person of another. So if I get to decide where Elizabeth lives and whether she gets medical care, I am her guardian in Arizona, if I've been appointed by the court. Conservator is the person who has been put in charge of another person's money. So we lawyers talk about guardianship of the person and conservatorship of the estate. And why am I slowing down and saying this very deliberately and repeating it several times? Because not every state uses the same language. In California, for instance, they speak of conservator of the estate and, confusingly, conservator of the person. In New York, they talk about guardian of the person and, confusingly, guardian of the estate. And so you have to be careful when you talk to your brother in another state. When you say, I'm going to go get guardianship over mom, you probably want to tell him exactly what you're getting, because in his state, when he talks to the lawyer and says, my sister's going to go get guardianship over mom, that lawyer's going to say, I knew she just wanted to get at the money. No, not in Arizona. Guardianship is just the person. Conservatorship is the estate. Is your Arizona guardianship valid when you go to California? Maybe. Is your California guardianship, well, it has to be a conservatorship. Is your California conservatorship valid when you come to Arizona? Probably. Probably is stronger than maybe. And I intentionally chose California because California is a little bit of an outlier. It's less likely that your Arizona guardianship will be honored in California than in Colorado or Iowa or most of the East Coast. And it is more likely that your out-of-state guardianship or conservatorship will do everything you need to do in Arizona than is true in most other states. We are pretty likely to honor your out-of-state documents. But there comes a time when you're dealing with Ryan's agency when they're going to say, you know, you've got a 12-year-old Louisiana tutorage and we don't even know what that means, and we're anxious about this. We want you to go get Arizona authority so it's clear that you have authority to act. So it's not an easy, yes, it will always work kind of answer. If you have a financial power of attorney and you take it into a bank, and let's just to give the bank some initials, let's call them Wells Fargo, and you take it into Wells Fargo, they will say, oh, this was signed on a Thursday, and besides that, it's on letter-sized paper. And we're not sure what the font is, but yeah. So you need to bring your mom in to sign our power of attorney, And when you say, mom actually is in a coma, and that's why she signed this power of attorney 6 years ago, is because she feared she might be in a coma. Well, bring her in. I've actually had bankers from Wells Fargo say that. Bring her in and we'll see about it. No, we're not going to wheel her bed down the street to have you decide whether to honor it. So when we do powers of attorney for people, we frequently say, when the bank tells you that the power of attorney won't work, call our office. Part of our service is that we will yell at them for you. But in the meantime, you might want to just go sign the Wells Fargo power of attorney rather than have that fight later. We don't like it. We hate it, in fact. It makes us crazy. But the path of least resistance might be to sign the Wells Fargo power of attorney. In general, in all of these arrangements here, when you are acting for somebody else, you are doing it in what's called a fiduciary capacity. You are their alter ego, but you are not them. And so your creditors don't have access to their money. You're doing this in that different capacity. When you're acting as fiduciary, you're not liable to take care of your principal with your own money. So if you get guardianship or power of attorney over your dad, you don't have to use your money to pay for his nursing home bill. And your creditors don't get access to his money. They're really separate kinds of things. If you use a power of attorney, it doesn't come back on you. And let me tease that out a little bit and tell you why you don't want to just put your kids' names on. If I had $1 for every client who said, I just want to put my son's, or usually my daughter's, name on the account in case something happens to me, I always say, you mean like you die? Because we say die here, because that's what's going to happen to you. I don't do that. I always want to. If you put your daughter's name, if you walk into the bank and say, I want to put my daughter's name on the account in case something happens to me, what they will do every time is make her a joint tenant on your account. And that means, guess what? you are exposed to liability for her creditors, and vice versa. So you don't want to do joint tenancy. You want to use these fiduciary relationships, one of them, in a general way. And of course, people do joint tenancy anyway, and I understand why, because my daughter is a saint, and she will never get in any trouble, and she will never steal from me, and her brother can trust her completely. So that means your kids are trouble, because statistically, you know. Voluntary and involuntary mental health treatment, we got to talk about them as a separate kind of thing. They don't really involve substitute decision making, except that when you're in the mental health system, they're making the decisions for you, and even your agent on your power of attorney may be trumped by the mental health system. And I already flagged for you, there is such a thing as a mental health care power of attorney, so there's a little bit of interaction between the fiduciary surrogate decision-making process and the psychiatric care arena as well. In a general way, the law makes a big distinction between those kinds of mental health treatment that look like chains and those that do not. Why do we make that distinction? Because we lawyers always reason by analogy. So we say, if the state wants to lock you up in the Pima County Jail or the Arizona State Prison, we're going to make them jump through a bunch of hoops before they do that. If they put you in the Arizona State Hospital or in a locked psychiatric ward, that looks a lot like prison, and so we're going to make them jump through a bunch of hoops before they do that. Whereas if you're in a nursing home and you're getting psychiatric antipsychotic medications, we say, oh, that's not like chains at all. That's just medical care, and so we're not going to make people jump through a bunch of hoops to do that. That's overgeneralizing. I don't want you to take that one to the bank. Guardians and, for that matter, conservators have to account to the court. And the way I usually describe this to people is, you may think, I've gone to court, I've paid the big bucks, I've invoked the legal system because I'm obviously the person who has dad's best interests at heart, and I need to be given the authority to make these decisions. That may be the way you view it. The way the judge views it is, your dad needs somebody to make the decisions for them. I, judge, will make the decisions, but I'm going to appoint you to do all the heavy lifting, to do all the work. But you answer to me. I'm going to make you come in once a year and tell me what you're doing, and at the drop of a whatever, I may decide that you're out of there and somebody else is in. And you have essentially no rights. You just have the obligation to make appropriate decisions for your dad. Now that's a little bit harsh. Generally speaking, the judges adhere to family wishes most of the time, maybe even in the vast majority of cases, but they have a different mindset. The judges are thinking, I'm in charge, I'm letting you make the decisions, while you're thinking, I'm in charge, the judge said so. You're not really in charge, the judge is really in charge, and you got to be clear about that. In guardianship cases, not conservatorship cases, all you have to do by way of reporting is to send about a 3-page form once a year to the court. You don't have to physically go down to the court and stand in front of the judge unless you haven't filed the form, or your form says something that makes the judge twitchy, in which case the judge may tell you you need to come down and explain yourself. But usually just filing this form is all that's required. But you do have to file that form. If you don't, the end result, it takes 6 months and a bunch of notices from the court, but the end result is a warrant for your arrest. And the next time you have a speeding ticket, you get to spend a night in the Pima County Jail until you can be taken down to explain to the judge why you haven't answered his mail. And so you're really under the thumb of the court and required to do some things. Advanced directives is a term for the whole collection of things that you do to say what you would want to have happen in the event that you became incapacitated. That can be a healthcare power of attorney, it can be a living will, it can be what's called a pre-hospital medical care directive, which is sometimes referred to as the orange form. It can even be a do not resuscitate order in some places, although the orange form and the do not resuscitate order are sort of overlaps in Arizona. It can be a letter to your child saying, if I ever was in a coma, here's what I would want. I'd want you to tickle my feet with a feather and blow flour into my face to see if I sneeze. They can be very detailed. They can be very vague. They can be, in your language, they can be forms. How many of you have seen the 5 wishes? A couple of you have seen those forms. There's a company a nonprofit in Florida that has been promoting them for about a decade now, and it's got a very flowery, feel-good view of your deterioration and death. I feel like death is a natural part of aging and it should be embraced. And yeah, what does that tell us? Does that mean you want tubes or you don't want tubes? But it's a start, and it's a good place for you to do check boxes and tell people what you want. And so if you're thinking about your own situation, fill out advanced directives. More detail, the better. If you're thinking about your mom's situation, if you can get her to do that, great. More important than all of this is the importance of having a conversation about it. So it's not enough, in my view, to get your mom to sign that healthcare power of attorney. She needs to tell you something about what she wants. When she says, oh, this is so difficult to talk about and you know what I want. No, you don't know what she wants. You know what you want, and you can guess that since she raised you, you probably have similar values, but you don't really know what she wants, so ask her what she wants. Even if she's incapacitated, ask her what she wants. Why would you ask an incapacitated woman what she wants for end-of-life care? Why would you do that? They're incapacitated, right? Because two reasons. One is even her incapacitated self probably has some vestige of what she would have said when she was competent. And the other is, if she says something different now, you kind of in a general way want to follow what she says now in her incapacitated state, rather than making her miserable to either extend her life or not extend her life over her objection. So that gets us to, when you act as somebody else's fiduciary, guardian, agent, any position in which you're making decisions for someone else, your job is not to figure out what you would want if you were in their shoes. It's to figure out what they would want in their shoes if they could just wake up for a few minutes and have a rational conversation with you about it. And that, by the way, is what we in the legal system call substituted judgment, and that should be the way in which all of your decisions are made when you're making decisions for others.
When you're obtaining a guardianship and conservatorship, a key component, which I'm going to be discussing, is notice to interested parties. There are certain parties that have to be notified, but you may want to be on top of things, or certain family members have to be notified. Often the case managers or behavioral health people and everything are not notified. The attorney is not made aware or doesn't think to ask of what agencies are involved. And I think the best thing is just, keep track of what's going on with your people and make sure that you're at that hearing or can register an objection prior to the hearing. I wanted to touch very briefly on surrogacy. Arizona has a number of surrogacy statutes that actually lets the healthcare provider choose a decision maker. And I don't know the extent to which this goes into mental health law as well, but often when a family member or a concerned neighbor or somebody brings someone in to a hospital or to a doctor, the healthcare provider, the hospital or doctor, can actually designate a decision maker. It doesn't apply to end of life. There's actually a priority list, but sometimes it's an expedient way for, if someone has a broken leg or something, just to get consent to fix it. When Robert and a little bit me were talking about capacity of people, not so much now, but 15, 20 years ago when I started, I would meet with incapacitated people, usually because I was court appointed, and I would say, I'm just going to ask you some silly questions. Who's the president? Roosevelt. I got that again and again and again. But then in the course of the discussion, if I said, if you're in a coma, and I wouldn't have to get any farther, I don't want to be put on machines. So people who really were not oriented to date and time and place and everything, that was such a huge issue for them. I do not want to be put on machines. So it's, again, getting their wishes, even if they're incapacitated, very important. A person who's appointed guardian can certainly have authority to take a ward to the doctor, and if the ward has mental health issues, they can certainly get you know, antipsychotic drugs or mental health medications. They can certainly compel the person to take those medications. They can direct the care home, make sure they get those medications. But a guardian, simple guardian alone, cannot have authority to actually put someone into a mental health level 1 inpatient psychiatric facility. An irrevocable, revocable or irrevocable power of attorney, mental health power of attorney can affect that, but with a simple guardianship, you can't do that. So one of the things I'm going to be talking about is that you can get that added feature to a guardianship, basically consent to an inpatient facility. If the healthcare power of attorney includes language, or if there's a mental health care power of attorney that the principal signs giving the agent the authority to place him or her in an inpatient locked psychiatric facility, then the agent has that authority. If it's set up so that it's irrevocable, and if the principal during his capacity, and presumably at a low ebb with his mental health issues, if he makes it irrevocable, then that means that when he's decompensating, that the agent absolutely does have that authority. And I think that usually the circumstances are so urgent, I just don't think that people generally have a problem with admission. If the doctor agrees and if the language is explicit in either the mental health power of attorney or a general healthcare power of attorney that includes that language, generally there's delighted to have paperwork and they'll honor it. The mental health component aside, powers of attorney are revocable. This is why, again and again, even when people have signed the documents, we find ourselves needing to go to court. People may have a healthcare power of attorney, but if mom refuses to move to the care home, she just says, I'm not going to do it, then and if she's also at extreme risk, she's not taking her medications, she's refusing to cooperate, she's setting fire to the kitchen, she's letting bums live in the living room and stuff. I mean, really some amazing stories, I always say directing traffic in their underwear. I've actually had that happen. People who are just at such extreme risk, but they say, no, I refuse. Even though you, my daughter, are my agent, I refuse to do what you want me to do. Your healthcare power of attorney is no good. Even if you kind of brought mom and said, we're going to have lunch at a new and different place today and take her to a care home, if she says at the care home, you know what, I don't like it here, I'm going to call a taxi and go home, the facility, the healthcare power of attorney is not enough for them to hold her there. And it's just the Constitution at work. It's kidnapping, they just can't do it. They might try to convince her for a week or two to try it, but ultimately it's not going to be enough. Same thing with the financial power of attorney. I had someone call the bank and say, I know my child is named my power of attorney, I don't want my son anymore, but I really, really trust the guy who drives the taxi when I go and get my groceries. I want him on my accounts. Banks are getting better and better about trying to report these when they see that someone's clearly being exploited or at risk. But that's really, what Robert was talking about is all the alternatives, and by all means, use those alternatives, see how far you can push them. Most powers of attorney work most of the time, but it may just be that they're just not enough. A lot of times there are no powers of attorney. A lot of times it just never happened. Sometimes there's just a situation where someone is just at risk living in their home. Generally the way it works is if there is a family member and there's kind of any family member obviously can initiate guardianship. Interestingly, guardianship can also be initiated by non-family members, by neighbors. I've seen amazing things where people just say, you know what, the family isn't doing anything, I'm going to go to court and see if I can do something to protect this person. But it's a process. And what I usually tell people is, when you are seeking guardianship, it isn't just so you can have that piece of paper. It's so that you really understand that you are going to override the bad decisions of this person. If they have to be in a care home or a safer place and they're refusing to go, then having that piece of paper isn't going to change their minds. It means that you may have to get law enforcement. You may have to hire people to put mom screaming onto a gurney and have her transported to the place. I had one woman who was transported by police car and did some business in the back seat just to show everybody what she thought of it, but she still got there. She got to the place. Once the care facility has evidence that you've gone to court and get guardianship, they absolutely do what you tell them to do, which is keep the person there. They can try to call a taxi, they can try to leave, they can do all kinds of things, but they have the authority to do what's necessary to keep that person there. Generally, I won't say always, but generally, once the person is moved, especially men, they're just so, I think they sort of forget what their homes were like, but they're on a schedule. They're getting decent food, they're getting their medications. They may fight it for a while, but generally once they're in there, you know, they're being taken care of and they're socializing and they're watching big screen TVs sometimes, and they're you know, so it's a very difficult time for families during this transition, but often, maybe even most of the time when they're in there, the adjustment is good. The whole idea of getting guardianship and conservatorship is that you have taken constitutional rights away from this person so that they can no longer make these decisions. The point of Robert's talk, and I agree with it, is that you try everything else first. Because if, you know, generally powers of attorney do work well. People are often very compliant. They're perfectly happy to have an adult child start, you know, writing out their checks and having them sign them or whatever. You try to do whatever you can to stay out of court, but for many people, not millions, we have found that fewer people are seeking guardianship and conservatorship than they were 10 years ago. But it's just a court procedure whereby you get to override that person's decisions. So regardless of what they're telling people to do at the care facility or at the bank, you as the court-appointed guardian or conservator override that and say no. And actually, I find care homes are incredibly tolerant. I had one client of mine call the police and say she'd been kidnapped. And the caregiver looked out the picture window and there's a wall, and behind the wall was a SWAT team. And she, you know, they didn't check to see whether it was a care facility, but they said, oh yeah, just another day with Ruby, you know. But it's generally they are very, very good. And it is true that redirecting is huge. Absolutely, you can call a taxi. Let's have a sandwich first, just to give you some energy, and then you can call the taxi. Occasionally, not always. But I tell people when they are not compliant, when they say, I'm not going to move to a care facility, you say, all right, that's $3,000. You know, guardianship and conservatorship, you know, that might be $10,000. Do you really not even want to give this a try? Do you really just you know, try it for a week, and if you hate it, then come back? And sometimes the money component is convincing to them. But the process, like I said, this is not something where you can wing it. This is not something where you can just say, you know, I'll show up, and most of it I'm sure is intuitive, and I'll just sort of figure out, and I know the judge will give me what I want. It's not like that at all. It's a very, again, you're taking away someone's constitutional rights, so it has to be done in a way so that that person gets due process. There's a hearing, there's notice of the hearing, and someone had brought it up, they won't just take your word for it, there has to be a doctor's report. The added mental health consent, then it has to be a psychologist or a psychiatrist. For regular guardianship, without that, then you would need to have, it's a medical doctor or a psychologist or even a registered nurse can complete a form. There's like an 8-question form that is very easy to obtain. about what the court needs to determine whether or not there's an issue. But that medical report is always needed for the guardianship, always, always, always. You're making an allegation that the person, because of his or her early dementia or whatever, does need guardianship. If the person objects, and we're getting to that, a person, they're entitled to their own attorneys, not in every state, but in Arizona, if you're going to take away their constitutional rights, they're entitled to counsel. And if they say to their attorney when they meet prior to this hearing, I don't want any part of this. I've never been in an accident. I don't see why my driving privileges have to be taken away. I'm going to fight this. And it may well be that the attorney, but through the objection, that they can at least limit the guardianship in certain ways. It's tough. Generally, if there's dementia, the judge is going to see that as a progressive disease. In this day and age, that doesn't get better. That may change in the future, but for now, dementia is a pretty damning diagnosis. Now, it's different with mental health. The mental health component gets renewed every year because if people are compliant and on their medications and don't have any underlying issues, sometimes the guardianship gets terminated because they're taking care of themselves. You have to be, some of the rules of the court may seem kind of extraneous to you. It doesn't matter. If you show up at that hearing and if you haven't taken all the steps necessary, not only are you not going to get what you want, but the court-appointed attorney will have spent time unnecessarily. You may have to go to 2 or 3 or 4 hearings if you're not paying attention to dotting your I's and crossing your T's. Now, if you are applying for guardianship, the court-appointed attorney and investigator will be paid for by the county, typically. Sometimes people go ahead and pay that anyway out of the goodness of their hearts, but most of the time the county does it. I will say that people who serve on the list of court-appointed attorneys, it's very tough. It's a lot of time that you spend, and especially working with people who are representing themselves. Often they're turning to you for legal assistance when really you're conflicted out. You can't give them legal advice or legal assistance. And I've spent as much as 27 hours on a case where I've been the court-appointed attorney. It's really, really important that you respect the fact that the court and the attorney and the investigator are spending time on this. Now, as Robert said, guardianship is of the person. So yeah, if all you need is Social Security or something, just stick to getting guardianship. Don't worry about conservatorship. Back to the, we weren't going to spend too much time on the conservatorship today, but the forms are set up, the instructions and the forms are set up in such a way so that you can do guardianship by itself or conservatorship by itself, guardianship and conservatorship, and guardianship with the mental health component and or conservatorship. Now, there are also temporary proceedings. These are always sort of interesting. Generally, the thinking is that if something is happening that is so urgent that it can't wait the 3 or 5 or 6 weeks that it'll take to get a hearing on permanent appointment, you can and should file a petition for temporary appointment of guardian and or conservator. A typical example is mom has been hospitalized and the doctors there are saying, she really shouldn't go home. Even if she gets a little rehab, it's clear due to her dementia or other issues that she really shouldn't be living independently. So there she is at the hospital, they're ready to discharge her, and they're happy to discharge her to a care facility. She's going to fight it, but that's like a very, very good time to try to get temporary proceedings done. The court-appointed attorney can visit her at the hospital. She's already a little disoriented from being in the hospital. She's not in her home. She's going to be transported anyway, typically by ambulance. But that's a typical example where it just makes a lot of sense to do to do guardianship, temporary guardianship. With conservatorship, the emergency, and again, you have to convince a judge that the emergency is appropriate. Basically, what's happening is you're saying this is so dire that the constitutional rights of this person should be suspended without due process. You're doing this in 3 days instead of 6 weeks. They aren't going to have much time to mount a defense. In Pima County, at least, they will be visited by their attorney, and their attorney will appear at the hearing on their behalf. But, they're not going to have much of a chance to put a case together. So you have to really convince the judge that this is something that's really in the best interest of this person. Doctor's reports are the most difficult part of initiating guardianship. If they are in a hospital, we love it, because then you have a treating physician right then and there, not their primary care physician, but a warm body who can sign the thing. If you don't get that, sometimes, and this is another thing, when Robert was talking about springing powers of attorney, that says, oh yeah, my agent can take over if a doctor says I'm crazy, try to get, and I'm being facetious here, but when you say, Mom, you haven't been to the doctor in 2 years, let's go to the doctor. I know what you're doing. You're going to go and you're going to have them sign something saying I'm crazy. I mean, I've had springing powers of attorney that just took months because we were trying to get doctors. It's great if the person is going to the doctor on a fairly regular basis. If the doctor hasn't seen this patient in even 6 months, but certainly a year, they're going to say you really need to bring her in. I have a number of cases where, someone needed guardianship because they were making bad decisions, not taking their medications, driving when they really shouldn't be driving, that kind of thing. But they gave up check signing authority, years ago to someone else. They're perfectly happy to have someone else do the finances. So it's really the set of circumstances, the instructions and the forms that the Pima County Bar Association gives out are in packages, so you can do guardianship and conservatorship combined. Same hearing, when the court-appointed attorney goes to visit the alleged incapacitated person, they can cover both the guardianship and conservatorship issues, and then, one hearing. Robert was saying that, there needs to be an annual guardian report filed when you have guardianship. It's really not a big deal. I have probably 30 or 35 people that I send reminders out to for free. I enclose the form and the minute entry giving the date that it's due, and most people get on it right away. But then a lot of them I'll just find, months gone by, I haven't seen it, I send another reminder, and then pretty soon there's a minute entry from the court saying we didn't get it, and we're going to give them another date, and then that next date they blow, and then it's, the bench warrant for your arrest for not doing the guardian report. It's just, does she still need guardianship? What's her address? What's your address? And a key part of that annual guardian report is they are insisting, the court insists on having a doctor's report within the past year. They just want evidence that the person has seen a doctor in the past year. If they don't get it, they're going to reset the hearing again and again until they get that doctor's report. Although you don't have to have a doctor's report per se to get guardianship by itself, you do need to prove, and I just find the easiest way is with a doctor's report, you do need to prove that the person has a diagnosis, and this is what you were getting to earlier, that someone has a diagnosis or an issue such as with drugs, intoxication, or whatever, that they just can't manage their finances and they're being wasted as a result. Different judges and commissioners kind of handle this in different ways, but you just have to have something other than, that they're wasting their money. There are a lot of gamblers in this town, but, if they're not intoxicated or don't have any mental disability, they're allowed to waste their assets. Sometimes the family members have just had it, or they know themselves well enough to know they're just not going to have the patience or the time, if they're working 2 jobs or whatever, to deal with everything. If there are sufficient funds, then you can designate, you can nominate and have appointed a licensed private fiduciary. And there are a number of them in Pima and Maricopa counties. The state of Arizona, I think actually we had kind of the model program for this. These are people who are fingerprinted, credit checked, license bonded. Their powers get renewed every year. Their certification gets renewed every year, but they'll take this on. My experience with private fiduciaries is that they would rather not take on a case unless there's about $100,000 in the conservatorship that they can work with. If there's $20,000, they're going to spend down that quickly, and then they're stuck with being guardian forever and ever and ever. And some of them have remained guardians for 10 years. They don't get paid. So that's kind of why they're doing that. Public fiduciary is the fiduciary of last resort. When there is no family member willing to do it, if there is not a, the circumstances are such that a private fiduciary is not available to do it, they often refer cases to private fiduciaries, but the public fiduciary can act as guardian and or conservator. They don't act as trustee. They can't act as trustees, but they can be guardian, conservator, and actually even personal representative of an estate. And boy, there are some people that are real unsung heroes. The public fiduciary in town is down to 2 attorneys. I don't know how they do it. They have, some investigators and some case managers, and I don't know how they manage all the cases that they do, but they do. After going through all this stuff of a court hearing, you've petitioned, you've gotten the doctor's report, you've gotten, court-appointed counsel and an investigator, and you end up with this order and certified letters, and they walk into the bank, and the bank person says, well, where's the power of attorney? This is I need the power of attorney. So you often have to, even with the, definitely with the powers of attorney, but sometimes with the conservatorship letters as well. And when I say letters, there's actually a piece of paper, letters of guardianship, letters of conservatorship, and you get them certified. It's not the court order, it's not the petition, it's not the doctor's report, it is those letters that give you authority to make healthcare and financial decisions. Most of the time, I think 2,500 to 3,000 is about right for guardianship, although it can be a little less if the people are applying to the county for payment, the court-appointed guardian and conservator. But if there's conservatorship, I'm really estimating 5,000 now, because it's just, it's just a lot of work. And then with a conservatorship, the annual accounting, my firm I don't see hardly any of it. The paralegals do it, and the annual accountings are costing around $1,000 to $1,500 to do. It's a lot of money. So
I'm just going to spend just a few minutes on mental health treatment, because sometimes there are mental health issues wrapped up in a lot of these issues we're discussing. And Robert had talked about at the beginning of the presentation our motivations for this little project and these seminars that we've been putting on. And for me, one of the motivations for talking about alternative ways to help an individual with disabilities manage their affairs, whether that be medical, behavioral health, or financial, because we were seeing so many people pushed into the involuntary mental health treatment system because of the lack of alternatives. So again, I'm here representing the Regional Behavioral Health Authority, and we have a network of behavioral health providers in Pima County. You're probably familiar with some of the bigger providers: La Frontera, Cope, Kodak, Hope, Providence, Pantano, Marana Healthcare. These are some of the mental health providers in town. If you or someone you know suffers from a mental disorder and you're receiving access benefits or have been approved for the program for persons with serious mental illness, and you're eligible for enrollment with CPSA and assignment, and you would then be assigned to a service provider, and we call our service providers comprehensive many of them, because you can go to one of these places, such as La Frontera, for example, and get a comprehensive array of behavioral health services. And as I said, in the future, those services are also going to include general physical health services, medical services. And so, I think one thing we want to emphasize here today is that voluntary treatment, empowering the patient or the individual to make these life decisions on their own, that's always the best method. If you can get the person to agree, then you might not need one of these tools to empower you or to empower someone else. Now, I had mentioned this involuntary mental health treatment process as one of the motivations for being here. And if some of you aren't familiar with it, it might be commonly referred to as civil commitment, although the term commitment has sort of fallen out of favor because most people who are being treated for mental disorders are not confined to a facility or a hospital. Most of them get outpatient services. But there is a provision in Arizona law, it's contained in Title 36, that says if an individual suffers from a mental disorder and they meet one of 4 statutory definitions, they either have to be persistently or acutely disabled, gravely disabled, a danger to themselves or a danger to others, and the person is unwilling and unable to engage in treatment on a voluntary basis, then the court can issue an order requiring this person to receive mental health treatment. Much like the guardianship proceeding, the individual, the patient, there's a lot of due process protections for them. They will be appointed an attorney to represent them in the court process. And certainly they're entitled to notice and to participate in the hearing and to object and to testify. But ultimately, if they meet these definitions and the court believes the evidence is clear and convincing that this person needs involuntary treatment, then the court will so order. The person will usually be designated SMI, although not always. And through that SMI determination, the person would be eligible for enrollment with CPSA and assigned to a provider who would oversee this court-ordered treatment. The provider would manage the person's medications, require that they take medications, require that they come to appointments, and really supervise this individual's affairs. So if you're a family member and or a friend or a concerned citizen and this is sounding like, yeah, this sounds like something that my friend needs, you would fill out an application. And it's an application for involuntary evaluation, or if it's an emergency situation, you don't think the person can be safe in the community for just a few days without hurting himself or someone else, then you would file an application for emergency admission for evaluation. So there's 2 forms you might consider, and you choose one over another depending on how dire the need is. If you think the person is currently dangerous in the community to themselves or others, then I suggest you call 911. If it's less urgent, then I would contact CPSA, our customer service line, or some of you are probably familiar with what's formerly known as Southern Arizona Mental Health Corporation, or SAMHAC. It's now known as Pasadera. And Pasadera can give you information on these application forms and can really assist you in this process. We also have a 24-hour-a-day, 7-day-a-week walk-in crisis center, the Crisis Response Center, which is located at University of Arizona, proximate to UAMC South Campus. Pasadera is also a walk-in clinic. You don't need an appointment to see them, and they can help you through this process. But to get to your question, it sounds like you or someone has filled out an application for someone that you're concerned about, and what that would normally mean is some sort of inpatient evaluation. If it gets to that stage, generally 2 physicians are going to evaluate your loved one in an inpatient setting. And they're going to be considering these questions that I asked. Does the person meet these definitions? Are they persistently or acutely disabled? But maybe more to the point, they're going to ask, does the person need involuntary treatment, or are they able to engage in treatment on a voluntary basis? That's a lot of the reason why an ultimate order for mental health treatment is not entered by the court, because a physician at University of Arizona Medical Center South Campus, Palo Verde Hospital, Sonora Behavioral Health, a physician at one of those entities, those are our evaluation entities, has made a determination that the person can be a voluntary patient. Now, you may disagree with that, but that's a physician's clinical judgment, ultimately. So again, we offer services to persons who are on Access or in the SMI program. Our providers also will offer services through individuals that have private insurance or Medicare. So you're not limited if you're not on Access. You can get those services through your private insurance as well. So her question is kind of about, sounds like the benefits that might be available depending on if the person is SMI or on Access, the state Medicaid program. Certainly if you're on Access, it's actually pretty good insurance and will pay for quite a few of the services that you or your family member or loved one may need. So individual therapy, counseling, medications, doctor's appointments, transportation, all that stuff can be covered. If you're SMI and not on Access, you may have a more limited benefit package that will include medications, doctor's appointments, won't include things like therapy. So it certainly behooves you, if you have a family member or friend who's trying to get mental health services and you think they might qualify for Access, they should certainly be screened. And a lot of the providers in town, those providers that I mentioned, will help you with a screening for Access. We talked about a lot of stuff today, and depending on, maybe some of you have someone in the back of your mind that you're here thinking about. Maybe you're here just for education, and that's fine too. Depending on their facts and circumstances, depending on their capacity, you might consider one of these tools over another. If a person is completely incapacitated, then a power of attorney is probably not going to help you. You're going to need to turn to one of these other processes. So we're happy to stick around for a few minutes and answer some questions. There are some resources in the back. Please fill out an evaluation.